Hi, this is Dr. Cora Stack here. I just wanted to. I'm really kind of upset, I suppose, because of what was done to my research by Michael McGrath allegedly, because he stitched me up big time. But it wasn't just me; he stitched up all whistleblowers in the process. And this is how he did it. And it was cynical in the extreme, and it was the nastiest thing any minister could ever do to whistleblowers. It really was. It was extremely nasty to protect himself and the mistakes that were made, in the initial implementation, which were allegedly unlawful, and he didn't want to cover this up. This is what he did to my research. Moria gave the impression that he was helping me, and he would use it, to improve the legislation in the amendment. Moria, we'll see now what he really did allegedly. Oh, and now he's off earning massive money in the commissioner's office over there. And, it's not reprehensible, allegedly, what he did. So anyway, of course, the media are going to publish this, allegedly. Of course they are. And Ireland's silent voices, how the two. Let me try and explain it now, because it's so nasty and so cunning, And there are obviously solicitors behind the scenes here, but ultimately he was the one that enacted the legislation, and everybody in the Dáil agreed to it, including the head of the Labour Party, a constitutional lawyer, and also the president. To this massive stitch up, and here we are wondering where all this alleged corruption is coming from. Well, this just points a light on some of it, but it's major. And then what happens to anyone who tries to bring it to court? Let's say on their own, with no help, because of this very nasty sting. It's of course they never thought I'd spot it. Block, 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 block. You know, Well, let's see. The title of the YouTube video is you couldn't make it up, really. You couldn't. It's Ireland's Silence Voices, how the 2022 whistleblowing amendment blocks constitutional exposes. I don't know how I can laugh, but it's someone says make a brilliant movie. It's real life, unfortunately. It has real life consequences for people like me who have suffered many, many years because of this nastiness. On the 1st of January, thinking I was, doing the right thing, sending my wonderful research to Micheál McGrath, not realising what he was going to do with it. Oh, to cover up. Oh, it was a massive cover up and a massive scam and stitch up. Massive, brilliant, legal advice, allegedly. Oh, brilliant. On the 1st of January 2023, Ireland's legal landscape for whistleblowers changed dramatically. Legal landscape. The Protective Disclosures Amendment Act 2022, which amends the original 2014 Act, brought in sweeping reforms that were said to strengthen protections. But for many who aim to expose deep constitutional or systemic wrongs, the reality has been very different, as I well know. Only now. Commissioner's role, shrunken, redirected, neutralised. One of the headline changes is the creation. This is what I didn't know until I went around, because I tried to do a protective disclosure to try and expose all of this stuff that I was observing, to do with all the blocking and all of that, and that would have been the right way to do it, because that was the way the original act intended to help people like me, and this was all taken out by this commissioner's rule. Shrunken, redirected, neutralised. So one of the headline changes is the creation of the Office of the Protective Disclosures Commissioner. You see, I hadn't been following this up. Now, I can't believe Transparency Ireland did spot this, because I knew they were in the, they had asked me for my I think I would have spotted this had I been had I been asked to scrutinise the government on this, and I can't believe that Transparency Ireland didn't spot it. I just can't believe it. Or that any government minister or any opposition minister or opposition lawyer, and there's plenty of them there, including Ivana Bacik, didn't spot this. It beggars belief that they didn't spot it, or else they were all covering up. It just beggars belief that they didn't, especially constitutional lawyers of the likes of Ivana Bacik. It beggars belief. The act, maybe she missed it. No, I sent her that paper, and she never responded. I sent it to her, and she never responded. And that may have been, I don't know, was it after or before I think I emailed her, yeah. Someone of that caliber, you'd imagine, would stand up for ordinary people. The Act promises that the office can receive disclosures and redirect them to prescribed persons or other suitable persons. However, the power it holds is highly constrained. If a prescribed person or suitable person exists for the subject matter of the disclosure, the Commissioner must forward the report to them. But if no applicable body can be identified, particularly in constitutional or systemic domains that transcend normal regulatory jurisdictions, the Commissioner's power to act is ambiguous. The Commissioner cannot itself initiate court proceedings or enforce follow-up against public bodies beyond directing disclosures. Its role is more administrative than adjudicative. In other words, the Commissioner is not a substitute for judicial or constitutional oversight. This design means that in cases of significant constitutional import, like the one we're doing now, where no single regulator or prescribed person holds jurisdiction, the Commissioner becomes a dead end, not a gateway. Erosion of redress, burden shift, procedural complexity, and no venue scenarios. Under the 2014 Act pre-amendment, once a disclosure met the statutory threshold, a protected disclosure was presumed unless disproven. In now the statutory threshold, a protected disclosure was presumed unless disproven, and that was in proceedings, shifting the burden to the respondent to show it was not protected. This is the big thing, that it was in proceedings. That if someone said it's not protected, the actual law said that it is protected unless proven to the contrary in proceedings, and that means in a court, and that was missing from most of the policies that I looked at, and they're all gone now. Of course, we're all there. I got them all, bar Donegal and Wicklow, everything. So, and all the public bodies, the workplace relations, all those ones, all the different governing bodies, all the departments, a lot of them, and they were all the same, bar the central bank, and a few others. The central bank seemed to be way ahead of the rest of them, but still in the 2014 Act, this was the big thing in proceedings. So if the Act had stayed the same, I had the right to go to the courts would have to prove that what was going on was not unlawful, and that's very unlikely that they could have succeeded in doing that, and it was at their expense. So I would just have to wait. So the procedural requirements for disclosures, precise internal reporting channels, acknowledgement, diligent follow-up, timelines, confidentiality rules can be weaponised as traps. If a disclosure is considered by a designated person to show no prima facie evidence of wrongdoing or to fall outside remit, the process can be closed and the whistleblower may be left with no further pathway. Importantly, in constitutional or systemic claims involving issues of law, governance, public administration, the Act does not clearly guarantee that such claims may be escalated or even ever reach a court. If no prescribed body owns the matter, the whistleblower is abandoned. That's exactly how I found myself. And I wasn't a whistleblower. I was just trying to, it wasn't a whistleblower. I was just trying to expose that this carry-on was unlawful in a way that was consistent with what I thought was the law. Because I hadn't checked about. I wasn't aware of this. I thought the Transparency Ireland, would have spotted this, or some minister. I can't believe nobody spotted it. It's procedural maze is not theoretical. It becomes a barrier to justice. That's the key point. A barrier to justice. Cost litigation work lay litigants and the hidden postbox mechanism, because formal powers to litigate or enforce are absent for the Commissioner. The burden of litigation, collection of evidence, drafting legal challenge, enforcing orders, all the procedural documentations that can happen falls entirely onto the whistleblower's lap. So all the documents, if you're doing any kind of a challenge, the legal complexities are horrendous, and all of that then, because of this, falls entirely on the whistleblower, which they're bound to not bother or make some errors. The system expects lay litigants in particular to assume roles typically played by institutional litigants or teams of lawyers. Furthermore, the Commissioner's Office and other designated persons risk operating as a postbox, simply receiving disclosures, holding them or redirect them in limited ways without ensuring they ever reach the proper authority or court. I mean, the law kind of is such that it is designed like that. This is especially dangerous in case of constitutional breach, where oversight must lie with judicial review or constitutional courts. Exactly. So the design neutralises the statutory protections that were meant to ensure due process, accountability and constitutional scrutiny, prevents transparently public interest, constitutional or systemic issues from being adjudicated, ensures that only those with extraordinary resources and legal muscle can hope to succeed. Impact on whistleblowers and constitutional oversight. The combination of the above factors has a chilling effect. Many will self-censor knowing the path is blocked. Others will try to use internal channels only to have their disclosures dismissed on technical or procedural grounds. The constitutional or systemic dimensions of misconduct, where no specific regulator is in charge, remains invisible. The right to seek remedies become contingent on one's capacity to litigate, undermining the principle of constitutional fairness. In short, rather than empowering whistleblowers, the structure makes high-stakes constitutional claims impossible or virtually impossible to pursue under the Act. So that's really where we're at the moment. There's if you're dealing with matters going forward for the rest of time of a constitutional nature, you have really no avenue to the courts unless you're very significantly resourced and extremely rich, because you're taking on the might of the state with all their legal teams and legal divisions. It is an absolute it was treachery or treason allegedly by Minister McGrath to get himself out of a very difficult situation, which was obviously very clear to him once he was advised by solicitors about the unlawfulness of the implementation. Now, who designed the implementation of the Protective Disclosures Act 2014? Who were the people who designed that? And who kind of were the people? It had to be ministers advised by solicitors, but that's something I'm unsure of. That's something that worth investigating. Is that who are the solicitors involved? They won't show their faces. And they're excluded really from any kind of. They're excluded from any kind of wrongdoing, as I understand it, under the Act. They're not workers under the Act, but they do. What they've done here, is certainly it is reprehensible. And this is why in my view, it's tantamount to corruption. What they've done, and they've escaped because they're, as I understand it, they're not technically whistleblowers or workers under the Act. This is why I think we need to change the legal system. Now, all this is alleged, but it's pretty much on the money. I can't see this happening without, solicitors and loopholes, and they're the experts on the loopholes, but this loophole is treason, allegedly. Sorry, but I think I'm on the money here. But because it was my research, it's an awful blow. It's an awful blow, and we're hoping to go to the courts to get justice. Well, how could you get justice when you have every block and every barrier against you, and the law being designed to ensure that you had no hope without huge resources? And it's reprehensible in the extreme what's been done, not just to a person like me, but to anybody like me, going forward in time. And to the rights of whistleblowers or people who are truth tellers. I prefer to use that word, or researchers, academic researchers, absolutely silencing academic research really is what's going on here also. So it's reprehensible what has been done here under the auspices of McGrath, and certainly that paper made the threshold of a protective disclosure because it was full of acts of omission. Absolutely. So anyone that said it wasn't was not no, they were covering up for all the flaws in the original implementation. But that's the real sting for me, not just for me personally, but for anybody, all the future people that are in my position now that want to expose this wrongdoing are really, the barriers that they're going to have to face are massive. So well, that's the story. And I suppose the courts can do it whatever way they want, but I think this is going to look very badly on the courts if they're happy with what's been done to them by them being effectively excluded from the protective disclosures legislation using this commissioner's stitch up of a commissioner's brilliant. It was ingenious. It was ingenious law to introduce the commissioner's role. Really ingenious law, but was it really? Was it? No, it was treason of the highest order, allegedly, and the foul play of the highest order, allegedly.